special verdict form, you know, the jury was suspect for murder, they don't have to say which one it is. So in that case, we found the defendant guilty of first-degree murder. You know, the jury was instructed on premeditated and felony murder, and acquitted on the underlying felony. And that case said, well, we don't know. You know, maybe the jury. Maybe this is an inconsistent verdict. How are we supposed to know? So we don't know, so we're going to throw it out.
It could very well be that it was premeditated.
Right, so we're going to throw it out. We don't know.
Okay.
Text me and said
That,
so they want to
throw it out. That's what that opinion said.
Yes, you don't do
You know, so I called the AG's office. And I don't know that I had anything to do with it, but they made a motion to re-argue. That opinion was
Good morning, Your Honor.
Be seated.
They withdrew that opinion. So that is not the law. And in fact, there's case law.
That one opinion was an outlier, and then it was withdrawn.
Then it was withdrawn. So there is case law that, you know, as long as there's evidence to support
Premeditation.
one of it, then
That makes
that's
sense.
fine.
I think that makes sense. I mean, and I think that the law should be sure that, because if there's no evidence of premeditation, you wouldn't give the premeditation instruction, right?
Right.
You just go away, so to
Get
speak.
you late on
Mr. Mosley, did your client get a chance to look at that or listen to that video? Or
Yes,
tape
sir.
again?
We'll take, just listen to it, Your Honor.
Great, thank you. Let me just get this computer fired up. Okay, we are back in session on the record, and the state is present and represented. Defense counsel looks like we're missing one attorney.
It's okay, Your Honor.
Mr. Hobson's going to be coming in later?
Yes, sir.
Okay. And Mr. Okafor is present, and he's dressed in street clothes. I know before we left yesterday, Mr. Mosley asked if his client had a chance to listen to a 911 tape once again, and I understand that's been accomplished. Is that correct, Mr. Mosley?
Yes, sir, Your Honor.
All right. And 2:35 this morning, I'm up working on some civil stuff, and I get an email from Mr. Williams. Thank you for the jury instruction update.
Yes,
I think I am assuming that that's been sent to everybody, and we'll talk about that in just a moment.
Yes, Your Honor.
Okay. All right. Let me get, before we...
I'm sorry, Your Honor. There's one thing I'd like to add to jury instructions.
Okay.
Ask the court for an instruction for circumstantial evidence in this case, because this case was largely a circumstantial case. I'd ask for a special instruction on circumstantial evidence.
Have you submitted it?
I'm looking for one. I was going to the Supreme Court. I was trying to see if the Supreme Court had one that I could give the court.
I'll be happy to consider it once I know what it is.
Yes, sir.
Okay. Mr. Mosley, let me, some planning purposes at this point. I understand all our jurors are back. You wanted an opportunity yesterday. The state has rested their case. You wanted an opportunity to consider whether there were any motions you wanted to make after you spoke with your client.
Yes, sir.
Is that correct?
Yes, sir.
Do you wish to make any motions at this point?
Yes, sir. I'd make a motion for, sorry. I'll make a motion for judgment of acquittal in this case, largely because, Your Honor, the state had an obligation to prove each and every element of the crime charged, first-degree murder in this case, Your Honor. And in this case, what the state proved was a lot of circumstantial evidence, circumstances surrounding this alleged offense, but no direct evidence of any crime, Your Honor. And so we're asking the court to consider the fact that they didn't take away the reasonable hypothesis of innocence with circumstantial evidence. They have to do something to take away that reasonable hypothesis of innocence when they have a circumstantial case. In this case, they did not. Their best witnesses are Brienna Campos and Remington Campos. They're the eyewitnesses, and both those people seemingly exclude Mr. Okafor from being in the house, and they do not testify in this case that he shot them, broke into the house, or anything. In fact, Ms. Campos seemingly testified that the person that she had seen 4 months earlier looked totally different from the person that took her from her bedroom that morning on September 10th. Remington Campos was asked on cross-examination, when they walked you out of your bedroom to the living room, what did you see? Could you see the entire room? He says, yes, I only saw one other person. That person was a skinny person with long dreads, and that was Emmanuel Wallace, and the person who escorted him out of his bedroom was Donnell Godfrey. At no point has the state put Mr. Okafor either in the house, Your Honor, or anyone has testified that he was in the house. So they haven't met their burden in that case. It's my contention that, and I'm basing this on state versus law, 559 Southern 2nd 187. It says, whether the judge may send a criminal case to a jury if all the state's evidence is circumstantial in nature and the state has failed to present competent evidence sufficient to enable the jury to exclude every reasonable hypothesis of innocence. In this case, Your Honor, I don't believe the state has met that burden. I don't believe the state has met that burden to either charge on the indictment. Not first-degree premeditated murder, not attempted first-degree premeditated murder, not burglary, because they have only used circumstantial evidence. They've used, in this case, Detective Mareshi, who's lead detective, kind of manages the process, has not been an eyewitness to anything. He's taken information from his law enforcement officers, and they're extracting information from extraneous sources from around the crime scene, such as cell phone tower, alleged expert who admits yesterday that even the closest cell tower to the house didn't pick up these cell phones. The CST person, I believe it was, can't think of her name now, she stated she went there, she looked for latents, she looked for DNA, she looked for everything, didn't find anything to connect that crime scene to Mr. Okafor. The GPS person, the monitoring person, testified that the GPS monitoring system was unreliable, that she didn't even know whether it was the range of distance on that monitor was 10 feet, 15 feet, or 20 feet. Then they brought somebody else in trying to back that up. That gentleman said he had never been to Mr. Okafor's house at 1241 St. James Place, that he really didn't know what monitor was in that house. He thought they were all the same, but he couldn't tell me whether the range of distance was, what the range of distance was, whether it was 75 feet, 35 feet. So basically this case so far, Your Honor, has been the state's putting on evidence basically contrary to the eyewitnesses, and that is the eyewitness says he wasn't there, they didn't see him there. They're putting on the cell phone stuff and try to get Ms. Meg Hughes to say he had left home. The court made a ruling that really can't say that, say the thing was beeping. And then no one, of course, you have these two witnesses who have entered pleas with the state for testimony. Admittedly, they are circumstantial because they even say, we can't say whether he went to the house or not. He left from the gas station. Ms. Gordon said she told me to sit on the side of the road. I had no idea what the plan, the scheme was. I sat on the side of the road. Mr. Ciceron says the same thing. I don't know what the plan, the scheme was. I sat on the side of the road. I never saw anybody go to the house. I don't know what happened. So basically what you have all these strangest people testifying to certain little things. The eyewitnesses say, well, we don't see him there, and this is a circumstantial case. And based on that, I'm not so sure that's enough to erase a reasonable hypothesis of innocence in this case. And if that doesn't, then the court should grant a motion of judgment acquittal on these counts.
Okay, thank you. Response.
I have other cases like I'll have them to the court.
Thank you. Response.
There is no reasonable hypothesis of innocence here. There's a great deal of direct evidence that Mr. Okafor was directly involved in this. We have both Nestle Cicerone and Sharia Gordon saying that Mr. Okafor was the driver of the car, his sister's car that we see on the Accurina video, along with Donnell Godfrey and Emmanuel Wallace, who he was driving to the scene of the crime where the murders happened. We have his cell phone records putting him there. We have the actual cell phone, his cell phone, that we know he used that night. And there's direct evidence that he used it not just in general, but that night and during the minutes leading up to the murder and the minutes after the murder, where he had it. And according to Detective Ed Michael's testimony, that phone was at the house during that time period, or at least not long before the phone was recovered the next day. So there's a great deal of evidence that Mr. Okafor was involved in this. He spoke to Antoine McLaren just hours before the murder and said words to the effect of, "I can't let the witnesses show up. He's the only one who had a motive to commit this crime." So there's a great deal of evidence. There's no reasonable hypothesis of innocence, and certainly in the light most favorable to the state, there's more than ample evidence to support a guilty verdict. As to the circumstantial evidence instruction, let me quote from, there's been a great deal of case law about this. There used to be a circumstantial evidence instruction. That's a standard instruction that's been eliminated. Here's a quote from Huggins versus State, 889 Southern 2nd 743 at 767, Florida Supreme Court case in 2004. It was a death penalty case from Orange County, where the Supreme Court affirmed Judge Perry's refusal to give it, quoting an earlier Supreme Court case, Floyd versus State, saying, in quotes, "We have previously stated that when proper instructions on reasonable doubt and burden of proof are given, an instruction on circumstantial evidence is unnecessary." My research hasn't disclosed a single case where the Supreme Court has ever said that a circumstantial evidence instruction should have been given.
Your Honor, Your Honor.
On which issue?
Back on the circumstantial evidence, not on the instruction, Your Honor, but on the circumstantial evidence.
All right, briefly.
Yes, sir. Your Honor, Mr. Altman talked about, again, he talked about the cell phones, and the very thing he's talking about is circumstantial evidence. In the case of Jared Miller versus State of Florida, in that case, Your Honor, 417 Southern 2nd 257, they actually found his fingerprint in the house on a knife, and they consider it circumstantial evidence. In this case, there's nothing in the house. No eyewitness, nothing in the house. In that case, they found that knife with his fingerprint on it, circumstantial evidence, Your Honor, and they said in that case, the same principle. And that case was reversed because of the fact that the court allowed it to go to the jury, and the state presented no evidence to erase the reasonable hypothesis of innocence. That same case, there was fingerprint, knife in the house, circumstantial evidence, and it was sent back, tried again, because of the fact there was nothing to erase the reasonable hypothesis of innocence. Your Honor, I will, on the instructions, Your Honor,
No, don't go to that yet. We're not dealing with instructions. All right.
Your Honor, that's Jared Miller v. State, and I won't belabor this, Your Honor, because I know we need to move. But I also will cite, Your Honor, I have a hard time pronouncing this, Gosselminski v. State, 132 Southern 3rd, 678. Your Honor, it's a Supreme Court case for the same principle, 2014 case. I will cite, Your Honor, Smith v. State. It's another Supreme Court case, Your Honor, for the same principle, saying they have to erase the reasonable hypothesis of innocence if it's going to be a totally circumstantial case. And I know the state would like to get away from the fact that it's totally circumstantial, but that's what it is. Thank you, Your Honor.
Thank you. Motion is denied at this point. We'll deal with the jury instruction, and the court will consider it at the time that one is proposed. Defense, are you ready to proceed with your case in this matter?
Yes, Your Honor.
Have you had a chance to speak with your client as to whether or not he is going to testify in this matter?
Yes, Your Honor. And
Do you need more time to speak with him? I'm just asking you, Mr. Mosley, whether you need more time to speak with him.
You know, I've spoken to him. I'm going to make sure he didn't change his mind overnight.
I'm going to ask him about that too, but I'm just trying to find out whether you as the attorney feel like you've had sufficient time to speak with him about this matter.
Yes, Your Honor. That's
All right.
correct. Yes.
And do you contemplate that he will or will not testify?
I contemplate he will not
Okay.
unless he changes his mind overnight.
That's fine. Okay. Mr. Okafor, I need to ask you a couple of questions if I could, sir.
Sure.
Okay? And when I'm asking you these questions, it's going to sound like I don't trust what your attorney is telling me. That's not true. I trust him explicitly. I just need to get the answer from you. Have you had time to speak with your attorney about whether or not you would testify in this case?
Yes, sir.
Okay. You understand. You've heard me give the jury instructions and talk to the jury and multiple times. You understand that you have a right not to testify?
Yes, sir.
You understand that if you do not testify, the jury has been instructed and will be instructed that may not hold that against you. You understand that?
Yes, sir.
You understand the state has to prove this case without your testimony, and they cannot force you to testify in any manner.
Yes, sir.
You also understand that it's your right to testify, and if you want to testify, you can get on the stand and say what you want. You understand that?
Yes, sir.
You understand if you do take the stand, they have a right to cross-examine you.
Yes, sir.
Now, I want to make sure, I asked your attorney whether he had spoken with you. Now I want to ask you whether you've had enough time to speak with your attorneys about whether or not you wish to testify.
I'm still contemplating.
Okay. Do you need more time to speak with them?
Yes, sir.
Okay. Would you like me to delay bringing the jury in a little bit so that you can talk with them some more?
Yes, sir.
Okay. I will do that, and then I'll make some further inquiry in a few minutes, okay?
Yes, sir.
All right. We'll be in recess. Yeah.
So I'm moving to the other case.
We were sort of all doing it together, Judge. We were all sort of all right around the table. I find it unlikely, based upon my observation.
Just always trying to say.
I understand, Judge. I think, to my knowledge, the only issue remaining is that 3.12 interlocking instruction issue. And the circumstantial. Correct. But that's my understanding. Other than that, we're done. They were attached to the email as well.
I know that.
I showed them to them yesterday, and they
We haven't
responded.
gotten a response.
Correct.
Thanks. Have you ever tempted when you cite a case that you were involved in to say, like after those, period of hearing with closings? You're both obviously welcome to. I did want to talk about this stuff. We had a whole cafe, and sometimes it. I can't hear you.
Darn it.
Computer for a moment.
Four flat tires. Two and a half days?
We started less than that actually, because we lost the morning. Coleman kept screaming at me. Move faster.
So the jury selection took 5, 8 days, so it's actually 4 times slow.
Thank you. Mr. Okafor, let me go back where I was. Did you have an opportunity to speak with your attorneys again? And have you, in your mind, had sufficient time to do that? And I saw at least 3 of your attorneys speaking with you, Mr. Golding and Mr. Mosley and Mr. Ayanaku. You feel like you've gotten the information that you've needed from them, and you've answered you've asked them your questions that you had, and did they give you answers? Okay. And having spoken with your attorneys and having the ability to make your own independent decision, do you wish to testify in this matter, or do you wish to not testify and preserve your right to remain silent? Not testify? and you're comfortable with that decision. And Mr. Mosley, let me ask you, back to you once again, are you comfortable that you've been able to answer all his questions, give him an adequate response, you and co-counsel, and that he is making an informed decision and deciding not to testify? Okay. Thank you very much. Court will find that it's a knowing, intelligent waiver of his right to testify if he wishes to, and an intelligent waiver to intelligent acceptance of maintaining his right to remain silent. Mr. Mosley, you reserved opening initially. Do you wish to make an opening at this point? And will you be ready to call witnesses thereafter? Okay, all right.
All right, what was that?
He said he's going to rest after his opening.
I don't believe that is appropriate. The opening is supposed to be about what evidence will show.
That's what was my next question was going to be. If you are not going to be calling a witness or putting on any evidence, what would you be saying in your opening? Yes, sir. You certainly can. Yep, you're Mr. Altman.
Okay.
All right. I think, you know, the opening would have to be about the defense case, not a closing argument as to the state's case.
An opening is an opening, and it's subject to objection if it moves some other thing other than an opening. Do we have the pads down the jurors' chairs? Yes. Okay. And Mr. Mosley, do you need anything in any optics or charts or anything in your opening? Okay, you might pull that out there so you have it ready. And you might need to get our highly trained and highly skilled audiovisual person, Mr. Altman, to get that set up for you. All right, let's go ahead and bring our jury in. She already testified, I think, hasn't she? She reminding me to remind
Yes, sir. Yes, sir. Mr. Altman, sir.
Would you make sure that screen is on there? Looks like it may be. I think it may be. Yeah. Well, we're keeping it unpublished for right now.
All right, jury dinner.
Please be seated. Thank you all. Good morning. Thank you for coming back. Thank you for being on time. We have been in here working the whole time, I assure you, and we've been trying to shorten things a little bit for you to get this case to you. So has anybody contacted any of you or approached any of you about this case since you left here last night? If they have, please raise your hands. I don't see any hands. Has anybody conducted any research intentionally or accidentally on any of the issues, any of the parties, any of the attorneys, or any of the witnesses, or seen anything in the newspaper or on internet or any place else, TV, about any of those? Please raise your hand. And I don't see any hands. And has anybody seen any of the other jurors conducting any research in this matter? Please raise your hands. I don't see any hands. All right, the state has rested their case. If you remember when you went home last night, the defense now has an opportunity to present testimony if they wish to do so. You remember they did have a chance to cross-examine witnesses when they were here. You'll also remember at the beginning of the case, Mr. Altman made an opening statement, and I then turned to Mr. Mosley and said, your option if you wish to make an opening, and he wished to reserve until now, and so he's going to be making his opening statement. Again, what Mr. Mosley says is not testimony. It is simply an introduction of what he believes the evidence will show. Okay, Mr. Mosley?
This is an opportunity for the open statement because of what I expect the evidence to show. I expect that the evidence to show in this case that the best two witnesses in this case are Brienna Campos and Remington Campos. They're the only eyewitnesses.
Objection. This is not an opening statement. I don't believe Ms. Campos and Mr. and Ms. Campos are going to be called as witnesses in the defense case. This opening should be about what the evidence is going to show in the defense case.
Overruled.
That's it. The best witnesses in this case are Brienna Campos and Remington Campos. They're the eyewitnesses. All the witnesses in this case are going to be people who are talking about different facets of this case surrounding the area and outside the house where this murder took place. Evidence going to show that Brienna Campos had an opportunity to confront Ms. Okafor May 9, 2012, where she identified her.
Your Honor, I repeat my objection. This is a closing argument. This concerns evidence that has already been presented and is not evidence that will be presented.
It is not a closing argument. You need to be talking about evidence that you will present or items that will relate to the evidence that you present, but it is not a closing argument.
May I approach, Your Honor?
You may. Looks like our sidebar is working today, so. Please proceed. Can you all hear me? You're moving away from the microphone. That's the problem. That podium turns, if you want to.
Oh, that's better, Your Honor.
It doesn't slide forward, but it turns.
Okay, turns?
Yep.
Okay. As I was saying, the evidence in this case was going to show that this is a case that the state is built on circumstantial evidence, and that Mr. Okafor in this case doesn't fit the description that Ms. Campos said in her statement in this case. Mr. Okafor is a 6-foot-tall man, 224 pounds. His mother would testify to that. The evidence is going to show that at no point in this case anybody placed Mr. Okafor in the house, and Mr. Okafor shot anyone at all. Thank you.
Thank you, sir. Do you wish?
I'm sorry.
Are you trying to show something or
I'm trying
not?
to show Mr. Okafor's face.
Okay, he can hit that for you. It should
Can you all
be-
see that?
There it is.
You see it now? This is how Mr. Okafor looked on the day he was arrested, one day after this offense occurred. As you remember, testimony was that the person who pulled Ms. Campos out of her room had a close, fresh haircut with a defined razor line. Thank you.
Thank you, sir. Meg Hughes, please. Fran. Please have a seat, ma'am. Thank you again for joining us. I'll remind you want to be close to that microphone, and I'll remind you that you're already under oath, okay? Thank you, ma'am.
Yes, sir.
Please, tell us your full name, if you would, please.
My name is Meg, M-E-G, Hughes, H-U-G-H-E-S.
Please proceed.
Ms. Hughes, you testified in this case earlier, correct?
Yes, sir.
And I thought I asked you in this case earlier that had you ever had any problems with calling Mr. Okafor and hearing the beeping noises from his house?
Did I repeat the question, please?
I asked you whether you had ever called Mr. Okafor while he was on the home monitor, and did you ever call him and you knew he was home because you heard the beeping noise in the back?
No, sir.
You never heard that?
No.
Okay. I thought you said that that on occasions that could have occurred.
What I said is that I had had another defendant, not Mr. Okafor,
Now, may I approach the witness to see if this helps refresh her recollection? May I approach the witness to see if this refreshes her recollection?
Sure. Show counsel, what, if you would, what you're using to refresh your recollection, please.
I'm directing Ms. Hughes to page 228 of the deposition,
Okay.
and line 14.
Read it to yourself, ma'am.
Oh,
See if that refreshes your recollection.
or just from 9? Okay.
Which one? Ms. Hughes,
Yes.
does that refresh your recollection?
Yes, sir.
And what did you say?
It said that that I'd heard the box beeping, or the paragraph before said that
I'm going to ask you the question. Did you ever tell us that you had called Mr. Okafor house and that you believed that you had heard the box beep in the background? Did you ever say that?
according to that I did, but I don't. Okay.
Monica, I'm sorry, I'm not sure what Mr. Mosley is referring to.
It's a trial transcript, apparently. It's not a deposition she testified in.
This is,
This is not really a refreshing a recollection, it's really impeachment, so if there's a part that needs to be read in conjunction with it, the state can ask for that.
210.
I'm sorry, I couldn't. You need a bench sidecar? Folks, will be just a moment.
You want to bring it over here? I'll, okay.
That microphone's on over there, Mr. Altman.
Thank you.
problem, Judge. They're paginated differently.
Oh.
Ms. Hughes, just in case people didn't hear that, my question was, again, did you ever call Mr. Okafor's house and, I guess, to check on him and determine whether he was home or not, and you discovered that there was a beeping sound in the background?
I don't recall hearing that, but that statement, if you take just that one line, it says that I did.
Okay.
Does that answer it?
Yeah, that's fine. So,
Any cross?
And in fact, that statement was about the box being unplugged for a short period of time.
Yes.
So as part of your duties as a home confinement officer, do you recall this happening with Mr. Okafor or with other people?
I do not recall it happened with Mr. Okafor.
If the plug came out from the base unit,
Yes.
that would cause a beeping noise,
Yes, it would.
and that could happen on occasion with some people where the plug came out of the wall.
Yes.
And the simple way to resolve that would be to simply put the plug back into the wall, is that right?
Yes, sir.
You don't recall that ever happening with Mr. Okafor?
I do not recall him calling me and me hearing the box beeping in the background. Now, with other defendants, that has happened, and it was usually family members that would call because they couldn't take the beeping noise.
Okay.
And I would go through a list of things to correct the problem.
And one of those things to correct the problem would be to make sure the base unit is plugged in.
That it was plugged in, that that the base unit was plugged in, that the electric was plugged in, that they had the cords plugged in correctly, and then the last thing I would ask them, did you pay your electric bill? Because if they didn't have electricity, I'd even tell them to go plug the box into another outlet, because sometimes an outlet in older homes would go bad and it would just stop working. So we just have them move the box. But I can't recall with Mr. Okafor him ever calling me and saying that the box was beeping.
And you don't recall any situation where Mr. Okafor ever suggested there was anything wrong with the home confinement system, or
No.
there was beeping that was happening that shouldn't have been happening, or anything like that?
No.
Okay. I don't have any other questions. Thank you.
Redirect.
So Ms. Hughes, this is sworn testimony that you're now contradicting. This is sworn testimony that you're now contradicting?
This is, I can't
I say
understand.
this is sworn testimony that you're now contradicting.
No, sir, I'm
Okay.
not contradicting it. I'm telling you that I don't recall The way the equipment worked is,
Let me ask you a question.
okay.
Isn't it true that you were asked a question, and in fact, when you, on a number of occasions, when you receive alerts that indicated that Mr. Okafor was beyond the range of the magic box, you would call him. He would be, in fact, at home because you could hear the box beeping in the background, couldn't you? Your answer: I would hear the box beeping, sorry. If the box got unplugged, like if the unplugged the electric or on the phone, it would start beeping. And yes, I would hear that. You're denying that now?
No, sir, I'm not denying it.
Question, same page. And in fact, that did happen with Mr. Okafor on a number of occasions, didn't it? And you say, I believe so. You're denying that?
No, sir, I'm not denying it.
It sounds like you're denying it. We asked you a simple question, did you ever say it? And you said, and here in this
Sir, I'm
testimony.
not denying it. You have that written down. I'm not denying it.
So it did happen.
That's what's written in the writing. That's what's written down. I cannot recall talking to Mr. Okafor over the phone about his equipment.
Okay.
I cannot recall it.
In fact, didn't you say that Mr. Okafor had several alerts, short alerts, that was the indication that something was malfunctioning with his system?
Can you repeat that? I'm having a hard time hearing you.
I say,
Okay.
isn't it true that you said Mr. Okafor had several alerts, and that was an indication that something was wrong with his system?
In the beginning, when Mr. Okafor took the box home, there was problems with his box, and my partner went over there. Bright House was there, and he corrected it. I would say, like, for the first 2 days there was a problem, and we knew it. And I talked to Mr. Okafor, and my partner went over there.
Okay.
It was a wiring thing, I believe.
But didn't Mr. Okafor have these problems throughout the time you monitored him? And then you would call him to check and see if he was home, and he would be home?
Mr. Okafor had a lot of short transmitter being gone from the base unit, and he did have disconnects, but he always reconnected the stuff.
And so you
The
were calling
equipment.
him to verify
Sir,
that?
no, I did not call him every time, because sometimes this happened in the middle of the night or when I wasn't on duty.
Okay. But you called him on occasions when
Yeah.
it was going on?
Yes,
And
I
you
spoke
verified
to
that he was home?
Yes.
Okay.
Yeah.
Nothing further. Nothing further.
Okay.
Just to clarify, just 2 more questions.
Within that area, yes.
Just to clarify, the problems with Mr. Okafor's home confinement system were the first couple of days, is that right?
Correct.
And this was a wiring problem.
I believe it had to do with the phone, because it was Bright House that I was told by my partner that.
I'm sorry. Sustained. Restate, please.
So and when you talk about your partner, that's Kenya Cox, who previously testified here.
Yes, Miss.
She would go to the home.
She went to the home, and when she went there, Bright House was there, and
Sustained.
So these, whatever little problems there were with these little alerts were just for brief periods of time, is that right?
in the beginning there was an issue.
And just in
Yes.
the first couple of days? Or so?
Yes.
And after that, the problems were resolved, is that correct?
Yes.
So any problems with Mr. Okafor's system, with beeping, with whatever, with him being home and the system not operating properly was just in the very beginning. His
Yes.
home confinement back in June.
Yes.
And after that, the problems were resolved, and after that, there were no additional problems with Mr. Okafor's system. Is that correct?
No, not like there was in the beginning, because it was a wiring thing that they had to correct.
And your understanding is once the wiring was corrected after the very beginning, the system worked properly, and there were no instances where you were informed that there was still a problem.
Sustain. Restate.
I have no further questions. Thank you.
All right. Ma'am, you may step down. Thank you very much. Please be careful on that step. Let me see counsel at the bench for just a moment. Mr. Mosley. Who is it? I'm sorry.
Candace Ruffin.
Candace Ruffin.